Mr. Chairman, before you proceed, I just will encourage the zoning board members to please turn your mics on and speak into them so that the people who are watching and for staff when we review it will be able to listen to it.
All right.
Thank you.
Good.
And same for the members of the crowd that will be going to speak. Please make sure that mic's on.
Okay, the only matter on for tonight's agenda is a motion to dismiss an appeal in the case of Tevereau and Glanz, Plat G, Lot 2-138, Newton Avenue.
Thank you, Mr. Chairman.
You're welcome.
For the record, my name is Eleanor Salvatore. I represent the Dupreets in this matter. They are the owners of the subject property that the Tevereaus and Glanzes are appealing. The Tevereaus and the Glanzes are neighbors of the Dupreets. And tonight we are here for what I called last week a very simple question, which is whether the document prepared by Mr. Pimentel is a decision that would be appealable under state law and your ordinances. Oh, sorry.
Press the button. Oh, it was red. All of yours were red, so I thought it was okay. Mr. Chairman, I think it would be helpful if we hear from Mr. Pimentel and perhaps Mr. Solitro about their feelings or beliefs about this document. My understanding is that this was prepared as a result of a lawsuit that's been filed in Superior Court. And I believe that Mr. Pimentel prepared this at the request of Mr. Craven, so if we could just have Mr. Pimentel explain why he prepared this, at whose request, I think that would be helpful. Whether it was a final document, I think it might still be in draft. I think that Mr. Solitro put in writing that it was an unpublished draft, were his words. So I think it would be helpful to the board to hear some of that explanation from staff.
I mean, I think the context that it's written in would be important for us to hear. I'm assuming there's agreement with all board members on this.
And I'd have a couple of follow-up questions for Mr. Pimentel, if he could explain through the, my question is through the chairman, why he wrote this document, at whose request, what his understanding was for this document. If we could just get those questions answered, I think that would be helpful.
Do you have any objection to that?
I don't have any objection. I don't have any objection as long as I'm entitled to the opportunity to cross-examine.
Of course, yep.
Thank you.
Okay,
And I agree with counsel. I think that's the only way you proceed tonight is to put some testimony on the record. I think you'll hear from Wayne, and I'll echo the sentiments said by counsel. I think you'll learn that this is not a decision. I told you that last week. But ultimately, that decision, excuse the pun, is for the board to decide. And it begins and ends with the testimony of Mr. Pimentel. Again, I think he'll tell you that it's preliminary document. It's not in final form. It was for internal use, and it's not a decision. But I will leave it to Mr. Pimentel. I suggest we swear him in for the record.
is that okay with you? Okay, good. Go ahead, swear in Mr. Pimentel, please.
I do.
Yeah, no, that's fine.
Sure. Wayne Pimentel, Pimentel. So, yeah, this document was provided at the request of Mr. Attorney Craven for a pending law case in the courts, based upon existing zoning decisions dating back to 2001, or 2004, I'm sorry. It was basically, and I've got a copy of it here, and the title of it is Zoning Status Review. It was simply that. It was just to get an update on where the project stood in relation to the 2004 zoning approval that was granted for various aspects of different types of improvements on the property. So it was simply just to get an update on that review and nothing more. And I provided that internally to Mr. Craven. It wasn't something that was publicly distributed. It was a working document. So other than that, I don't know if there's any other questions that you have as a follow-up to that.
So it was distributed. It was distributed by an attorney named Mark Hickey. Did you ask him to distribute that document to anyone?
No, I wasn't aware that it went to him. It may have been given, I'm not sure how he received that document. I believe he's an attorney for the trust for the town. And so I'm not sure how that document did get to him, but again, it was more of an internal document between myself and Mr. Craven.
So Mr. Hickey does not represent you as the zoning official specifically
Not
in
that I-
in day-to-day matters? Is that
No.
correct?
In day-to-day matters, no.
Okay. Just in terms of, I mean, you do issue decisions and determinations, right?
Yes,
Okay. Do you typically put them on the town's letterhead?
sometimes.
Okay. Do you identify them as a town document in any way?
Not really. I mean, in this case, this one was not on town letterhead. It was simply just a Word document that I created.
Right, but that, I think it's your position that it's not a decision, right? So I'm
Oh,
asking, when you issue a formal decision or determination, is it typically put on town letterhead?
Yeah, the ones that I did, like a zoning certificate
Yes.
determination, other than that, I don't make any other zoning determinations. That would be left to the zoning board. So the only legal document that I can produce relative to zoning would be a zoning certificate. So this is definitely not any type of final determination on a zoning matter. Simply a working document.
And then, thank you, Mr. Pimentel. Mr. Chairman, I know that Mr. Salitro hasn't been involved in some of the correspondence, so I would ask Mr. Salitro, not perhaps through testimony, but just to confirm that it was his understanding that, and he put it in writing, that it was an unpublished draft document. So I would just ask Mr. Salitro to expand on that if he could.
I mean, frankly, I defer to Wayne on it. He's the one who drafted it. Oh, I'm sorry. I defer to Wayne on that. From his testimony, from what I previously knew, he crafted this document at the request of council to work on the document with council for whatever reason. Through Wayne's testimony, he tells us that it was a working document, a preliminary draft, and not public.
Okay, thank you. And then just, Mr. Pimentel, Mr. Mancini has attached several letters, both to you. The first one, I think, was issued in December of 2024, and others that were issued to, and perhaps you were copied on them, to either James Callahan, your town solicitor, or Robert Craven, the assistant town solicitor. Are you aware of those letters?
Yes, I am.
Were you responding to any of those letters when you wrote this document?
I was not.
Okay. I think that's all I have for now, Mr. Chairman. If Mr. Mancini wants to cross, and then I'll make my argument.
Thank you. Good evening, Mr. Chairman, members of the board. Through the chair, just a few questions for Mr. Pimentel, just to follow up. Good evening, Mr. Pimentel.
Good evening, Mr. Mancini.
Good to see you again. I know we've dealt multiple times, and most recently. So I just heard your testimony, and you've described this document as a working document, correct?
That's correct.
Okay. What makes this a working document?
It was just to give an update to Attorney Craven for the purposes of the ongoing lawsuit that was going on between the two parties.
Was this a document that was subject to attorney-client privilege?
I would assume that it was. It wasn't meant for any type of public distribution at all.
Did you ask Mr. Craven or anyone else not to issue this document to anyone?
I don't remember making that statement.
Okay. Did you indicate in the document that this document was not appealable or that it was not a decision?
No, I never said that statement.
Do you view this document to be a town document, a town record?
I mean, it's a record, but not in the sense of an official zoning determination.
But do you view it as, is it a public document?
Anything I produce is a public document, so in
And
that
is that,
sense.
I'm sorry.
Yeah.
So you said anything that you produce is a public document?
I mean, it's available for the public to view, with the exception of attorney-client privilege documents, which this fell under.
And was this labeled, or, we'll start that, did you label this an attorney-client privilege document?
No, I did not. I mean, I assumed that it was based on the fact that Attorney Craven is our legal counsel.
You indicated that this document was not final. What is not final about the document?
There were a couple of iterations of this document that were done, the last of which I believe is what was forwarded to you. But there were others where I did timelines of zoning approvals and building permits associated with the project to kind of give a status update as to what took place in the past relative to zoning and permitting on the property.
And so this document, start that. Did you prepare this document on October 28, 2025?
The one that you have, yes, but I had produced documents prior to that that were, again, working drafts of my data and information that I compiled based upon the zoning and permitting,
And did you submit those documents to anyone?
just to Attorney Craven.
And prior to October 28, 2025, did you meet with any of members of the DePreet team regarding this document?
I don't recollect meeting with them about this document.
Did you meet with any of DePreet's attorneys regarding this document?
Not that I can remember.
Okay. Did you meet with me regarding this document?
I don't remember that either, John, unfortunately.
Do you recall if you met with anyone from Mr. Tevero's team or anyone associated with Mr. Tevero?
No.
Okay. And I can tell you that I don't recall meeting with you on this document, correct?
That's correct.
And in this document, do you recall making an interpretation?
No.
Okay. So when you say anything other than that interpretation would potentially subject half of the property to that restriction, as technically half of the parcel sits on the westerly side and half sits on the easterly side. Do you recall making an interpretation regarding certain language relative to the 2004 zoning decision?
Yeah, I did, only because it was very unclear as to what that definition meant. So I was just trying to provide how I would interpret that, how I saw that.
Okay. And so in your opinion, is that your interpretation of the 2004 decision?
That's my personal interpretation. It's not the legal interpretation. And it wouldn't be it would have to go back to the zoning board would be the determination factor to determine whether or not that was the property line and whether or not my interpretation had any bearing on it.
And you say your personal interpretation. Are you the zoning enforcement officer for the town of Narragansett?
I am.
So when you drafted this document, was this your personal opinion, or was it your opinion as the zoning enforcement officer of the town of Narragansett?
It was my personal opinion as the zoning enforcement officer. Again, because it was such a gray area, there wasn't a specific definition on how it should be looked at. So that's why I kind of said, if I was looking at this, the way it's written, this is how I would interpret it.
And you state an option to resolve this would be to have the zoning board clarify what the westerly side of the property is. Did you recall saying that?
I recall saying that.
Is that a conclusion, an opinion, or a determination?
I think it was an opinion based upon that if there's still a gray area relative to that original decision, that perhaps the zoning board should weigh in to make that final determination as to what it actually meant.
So you testified that this is your personal opinion, and I just want to clarify that. Is it your personal opinion as a zoning enforcement officer, or is it your personal opinion as Wayne Pimentel individual?
I would say it's a combination of both. I mean, as crazy as that may sound, again, I wasn't asked to make a legal determination on that. That's not my role, that's the zoning board's role. I just simply read what the original 2004 decision said, and gave my opinion as to how I would view that. But it in no way is a determination by me as the zoning enforcement officer.
And so is it your opinion that this correspondence, this report, what you drafted, what you dated October 28, 2025, is of no impact?
It was information for Mr. Craven to use in the lawsuit.
And did you intend this to have any impact as to the relationship between Tevereau and Dupree?
Not intentionally, it could have, depending upon how Mr. Craven used my information and whether it was even going to be considered in front of the court.
Okay. Now, when did you become aware of the fact that this document was disseminated to the attorneys?
I think when I started receiving some of your correspondence on it. I don't remember a date, but
Do you recall receiving the, let's start that. Do you recall receiving emails between myself and your solicitor, Mr. Solitro?
I can't recollect totally.
Between October 28, 2025 and December 5th, 2025, did you at any point ever tell anyone that this document could not be appealed, or an appeal from this document was not permitted or not permissible?
I don't recollect that.
Okay. And do you recall receiving an appeal on December 5th, 2025 regarding this document?
I would have to check my records on those exact dates.
When did you first become aware of the fact that this document that you authored on October 28, 2025 was being appealed?
Again, I don't remember the exact date. I do remember that it was being appealed.
Okay. Do you recall submitting an email on January 2nd, 2026, indicating that you had met with Mr. Dan Dupree to discuss this document?
I don't remember that.
Okay. Do you remember drafting an email to anyone about having met with Mr. Dupree and about this document not being appealable?
Again, that's possible. Again, without reviewing my emails and my records, I really can't say 100%.
Do you recall ever meeting with Mr. Dupree about this document?
I can't remember specifically meeting with him. I've met him on site for other matters involving his property with current older permits that were still open that had to be closed out on his property, but I don't specifically remember discussing this with him.
And do you know why you did not, between October 28, 2025 and January 2nd, 2026, indicate to either Mr. Solitro or myself that this document was not appealable?
I didn't, because I just assumed that it would be handled by the attorneys and not myself. I didn't feel, I think I let it known that I didn't feel as though it's a document that was even appealable. It wasn't a zoning decision. And again, it was the title of it is a zoning status review. It would, by all matters, it didn't have the weight of a zoning board decision. So therefore, I didn't feel as though it was something that I needed to state. I thought, again, that our legal counsel would simply say that, yeah, this is not appealable.
And are you familiar with Section 32 of the town ordinances regarding appealable decisions?
I'm aware of that section, not specifically.
Okay. And that section indicates that any decision from the officer is appealable. And do you disagree with that section?
I wouldn't disagree with it if that's what's written in there.
Okay. And you consider yourself an officer of the town of Narragansett?
Yes.
And are you specifically the zoning and building enforcement officer?
Yes.
And what documents, let's write that, do you recall what particularly you reviewed in making that document and crafting that document?
It was the zoning record on file from 2004 onward, and the building department records from that same date onward as well, and just giving a recap of what transpired and the status of those either decisions or permits.
And do you believe that you made any conclusions relative to accessory building locations, side setback locations, pool equipment locations and enclosures?
Yes, based upon those previous decisions of the zoning board and building permit records, I gave a status update on where they fell based upon those.
And what do you mean by where they fell?
Well, the current status of those, either that they were complete, not complete, in compliance, not in compliance, that type of thing.
So when you say that something's either compliant or not compliant, do you view that as a decision? Do you make a decision to determine compliance or non-compliance?
I was simply reviewing the record of the original decision for Mr. Craven to use in the lawsuit.
Now, my sister asked you about a series of correspondences that you received from my office. Do you recall receiving letters regarding this 2004 decision concerning the location of certain items?
Yes.
Okay. And there were a series of letters. And the first letter commencing in December of 2024, the last letter ending in July of 2025.
I do.
Okay. And I just stopped sending letters. I was doing one a month, and I stopped doing them.
Yeah, I lost track myself.
Probably more. But do you, did you have an occasion to review any of those correspondences?
Yes, I
Strike
read.
that. Did you review those correspondence relative to this document dated October 28, 2025?
I can't, I mean, I read your correspondence. I don't remember whether or not it was reviewed entirely to referencing it back to my original document. But any correspondence I would have gotten from your office, I would have forwarded to our legal counsel to respond to.
And do you consider those correspondences to be part of the zoning file that you hold or maintain relative to 40 Newton Avenue?
Going forward, you mean? Would I?
Well, but prior to October 28, 2025.
I mean, they would be part of my file in the office, yes.
And so is it your opinion that this document dated October 28, 2025, prepared by you, is not a response to those correspondences?
Is not, you say?
Is not.
No, this was done at the request of Attorney Cravens simply for that lawsuit.
So have you responded to any of the correspondence submitted to you relative to 40 Newton Avenue regarding the 2004 zoning decision and regarding the accessory building, side setbacks, pool location, pool filter, and interpretation of the westerly side?
No.
So as you sit here, is there, to your knowledge, as you sit here, is there any response been filed or made by the town of Narragansett relative to the different correspondence submitted by the Teveros and Glances between December 12th, 2024 and July of 2025?
Not that I'm aware of. Again, I was assuming that all of this would be worked out with the court by Attorney Craven and Mr. Tevero's attorneys.
Do you know what is pending in court action?
Basically, some of the items from the 2004 zoning approval that are questionable, such as the plantings, the pool cabana or pool structure.
To your knowledge, strike that, to your knowledge, does the Dupree property have a cabana?
They have a structure that houses the pool equipment.
Okay, and do you consider that a cabana?
No. So I would want to correct myself. It's a shed structure that houses the pool equipment.
Okay, and that's important because I've heard cabana and read cabana, but to your knowledge, there is no cabana at 40 Newton Avenue, is there?
There's not. There was a permit submitted to construct a cabana.
Okay, and has that been granted?
No.
Okay. And just a few follow-up questions, and I promise I'm done. I don't want to go far afield, but it's both cross and direct on this. To your knowledge, were you asked by any Superior Court justice to prepare this document?
Not personally, not specifically. It was done at the request of Attorney Craven based upon what was transpired behind doors involving this case.
And did Mr. Craven give you any court orders or any other particular documents that evidences or requests your opinion regarding the 2004 zoning decision?
Just to do my review like I submitted in the October 28 document.
So, from this document, do you intend on drafting an additional document?
I'm sure at some point I will.
Okay. So is, in your opinion, you call this a working document, so is this document going to, at any point, be used by the town of Narragansett?
It may not be used by the town of Narragansett. It may be used by the courts to make some determinations.
And so do you intend the courts to rely upon this document?
I'm sure not only this, but the original zoning decision. Again, I just gave an update on the original zoning decision status and building permits that were pulled in relation to that.
Do you intend the town to rely upon this document?
In the future, once we hear back from what the court decision is on some of these areas that are gray areas, we will, act on those and clear this up.
But my question to you is, do you intend the town to rely on the document that you drafted on October 28, 2025?
That and the court decision.
Okay. Do you intend or know or expect Mr. Dupree to rely on this document dated October 24, 2025?
I'm not sure. Rely on it for what purpose?
The decisions and determinations that you made in here well, strike that. Let me ask you this. Do you believe that there's anything in this document that can be relied upon by either Mr. Tevereau or Mr. Dupree?
I mean, it's possible. Again, this is my review of it. You as representing Mr. Tevereau and the same with Mr. Dupree, they could come up with their own conclusions as to the status of the original zoning decision and permits that were taken out after that.
So my final question to you then is, in preparing this document as a zoning enforcement officer, having provided an opinion, why do you believe that your opinion is not subject to an appeal by an aggrieved party if they don't believe in your document or in your opinion?
It's not, I wouldn't consider it an appeal, an opinion. I consider it a review of documents. I didn't make an opinion. I basically looked at the facts of the 2004 zoning decision and the building permit records and basically just put down facts related to each of those.
But you make recommendations, do you not?
I don't make recommendations when there are areas such as what determines the westerly side. I did provide input as to what I thought that may mean, because it was such a gray area, and to this day it's a gray area. That's something that I think I may have referred to, that a zoning board or the judge in this current case may want to weigh in and make a determination as to what that actually is.
And you agreed with me that you made an interpretation.
It's possible.
The document says you interpreted something. You interpreted something, didn't you not?
Yes.
And do you not believe that that interpretation is something that can be relied upon by either the Duprees or the Tevereaus?
I mean, if I was around back in 2004 and I was at that zoning board hearing, I probably would have asked for clarification as to what the intent was.
But as the zoning enforcement officer today, aren't you charged with the responsibility to interpret the 2004 decision in order to enforce compliance or non-compliance?
Yes, but again, this is currently, being fought out in the court, and I would let the courts, weigh in and make that determination.
So let me ask you this then. Did you or did you not, as a zoning enforcement officer, make an interpretation of compliance or not compliance with the 2004 zoning decision vis-a-vis this October 28, 2025 correspondence, letter, report, status?
I made an interpretation, but I did not make a determination as to what needed to be done.
So is it your opinion, based on what you did as a working document, that parties should not rely on it?
Oh, yeah, I think the whole purpose of it was for this to go to Mr. Craven, for him to use in the court case, for them to rely on all of the facts, including where I gave a status update as to what was the intent.
And you testified earlier on direct that you did not mean for this document to be distributed. Is that correct?
I didn't expect it to be, it was between myself and Mr. Craven.
Okay. So when you learned that I had the document and that I appealed the document, any reason why no one said that it could not be appealed?
That wasn't, no, there wasn't, not in my case, and that was not in my purview to make that determination.
Okay. I have nothing further. Thank you.
Can I just ask a couple of questions of Wayne, just so we can clarify something? So, Wayne, when you receive a complaint of a zoning violation or a complaint of alleged non-compliance with a zoning board decision, you would conduct an investigation, correct?
Yes,
And if you found the complaint justified or non-compliance with a zoning board decision, you would issue a notice of violation, right?
correct,
And that notice of violation would be on town letterhead, correct?
correct,
And that that notice of violation would be signed by you,
yes,
and that notice of violation would also be served on the violator, correct?
correct.
So that they would have an opportunity to be heard on that or cure the non-compliance.
Yeah, and it would also include information relative to the appeal process.
Okay. And that, something like that would be appealable to the board, and we've seen.
Correct.
At least I
Yeah,
have since being on here.
Seen too many of
Over
mine
many
lately.
years, yeah, with my sister counsel there.
We've become friends. We've
right,
had
thank you.
a lot of cases before this board on
Okay.
other matters.
Thanks.
Thank you, Mr. Chairman. You heard an awful lot of questions from Mr. Mancini, but what Mr. Pimentel testified to is that this was not a final decision, that it was intended to assist Mr. Craven relative to a pending lawsuit. He also said that he will be perhaps drafting additional documents, meaning this is a work copy. And he also testified that it's not an opinion. This is clearly a working document, and I also just want to say, Mr. Pimentel, not being an attorney, might not be familiar with the Access to Public Records Act, but working documents are not subject to public disclosure. So there was no intent to disclose this. It was some attorney from the trust who got his hands on it, we don't know why, and it was mistakenly distributed to the parties, including us. So I just want to say that, a lot of the questions that Mr. Mancini was asking Mr. Pimentel, for I don't know how many of you are lawyers on the board, but were clearly legal questions and not factual questions. The ones that I just addressed were facts, that in Mr. Pimentel's mind, he was addressing a request from Mr. Craven, and it was intended for the courts, and he was not responding to any of these letters, which I'm happy to go through, but they were also not requests for information. This matter is a part of a collection of strategies by the DePreet's neighbors, the Teveros and the Glances, in an attempt to delay, impede, and prevent the lawful use of the DePreet's property. There was a 2004 decision issued by the zoning board with certain conditions that the neighbors are using in an attempt to persuade the town that there are zoning violations on the DePreet property. However, this entire process is an exercise in futility. In their purported appeal of a document authored by Wayne Pimentel entitled Zoning Status Review, the neighbors are specifically asking the zoning board to enforce and mandate compliance with a decision issued by the zoning board in 2004, when the zoning board has no such authority. As you said during the last meeting, Mr. Chairman, the zoning board of appeals may hear appeals on notices of violation, but you certainly may not unilaterally enforce the provisions of the ordinance or the 2004 decision. There are no violations issued against the Dupreets or their property, so enforcement is not before you. Importantly, the Supreme Court has held that owners of adjacent property are not entitled to bring mandamus action to require zoning enforcement because only a municipality can initiate action to enforce zoning ordinances. And I'm citing O'Neill versus Carr, which is a 1987 case. In addition, Rhode Island General Laws, Section 452460, specifically calls out that it's the town that enforces zoning through the courts, either Supreme, Superior, or in some instances, municipal court. But there's no such statute authorizing a neighbor to enforce or seek enforcement through the zoning board or court. And I want to be clear, that's what his appeal states, is that he wants you to enforce and mandate compliance with the ordinances, and there's no jurisdiction for that. In fact, as we've discussed, the neighbors filed a lawsuit against the Dupreets that is presently pending in Superior Court relating to their illegitimate complaints and asking for a declaration that there exists zoning violations on the Dupreet property. The case was filed against the Dupreets in December 2024. Upon filing the complaint for the neighbors, Attorney Mancini wrote a letter to Wayne Pimentel notifying him of the lawsuit, summarizing the grievances, and requesting that he issue, guess what, notices of violation against the Dupreets. That's his first letter in Exhibit B that's filed with his opposition or objection to our motion. There was no request to make or consider any particular interpretations of the ordinance or of the 2004 decision. The letter simply demands that violations be issued based on the arguments contained therein. Thereafter, every letter sent to the town, all attached in that Exhibit B, was addressed to either the town solicitor, James Callahan, or the assistant town solicitor, Robert Craven, or both. Obviously, neither Callahan or Craven are zoning enforcement officers with the authority to respond to a request for information. So these letters requested are irrelevant. These subsequent letters to town attorneys ask the town to review comments, issue violations, refrain from issuing future permits for improvements to the property, and demand that the town require the Dupreets to apply for additional relief from the zoning board for existing improvements when none is required. As for this Gateway case that Attorney Mancini cites regarding a non-decision, that case is inapplicable because the neighbors never requested a decision from the zoning official. And clearly, it was Mr. Craven that asked for this document, an internal work product, for him to use in this court case. I would also note that the neighbors never attempted to appeal any of these non-decisions from the town since the first letter in December 2024. So they've waited until Mr. Craven asked for this, and now all of a sudden it's all these letters that Mr. Pimentel is allegedly responding to. The zoning status report was drafted by Mr. Pimentel at the request of Mr. Craven after, well, the court suggested that perhaps the town should weigh in on zoning matters complained of by the neighbors. In fact, Mr. Mancini communicated to the town solicitors in one of his letters, June 2025, that we think the proper forum to adjudicate the legal rights that stem from the 2004 decision is the Superior Court. For that reason, he said, we filed a declaratory judgment action in late 2024 seeking a declaration from the court as to the abutters' property rights as they flow from the decision. Moreover, he said, we believe that the determination of the legal rights emanating from the decision is best suited for Superior Court, whereas the zoning board lacks jurisdiction to make conclusions of law relative to property owners' rights concerning this 21-year-old decision. And that is at Exhibit B. It's within the context of this Superior Court case that perhaps the town should review it. We've already gone over this. Mr. Pimentel was asked by Mr. Craven, in fact. Attorney Mancini cites an objection that the court, quote, preferred that the zoning board to rule on the neighbors' complaints about the alleged violations of the current ordinances and the 2004 decision. Even if that were true, jurisdiction of the board, that is not within the jurisdiction of the board. The Rhode Island Supreme Court has held that the zoning board has no authority to issue advisory opinions. There's a case titled Franco versus Wheelock, and the court said an advisory opinion issued at the request of the town council was non-binding, unauthorized, and an unenforceable determination. The zoning status report was not a response to the letters submitted by Attorney Mancini. Attorney Salitro, the assistant town solicitor, characterizes the document as an unpublished draft. My brother also cites the case of Contemporary Associates versus Murray, where the court looked at the totality of the circumstances as to whether a document was a decision and therefore appealable. We heard from Mr. Pimentel where he said that, well, on your questioning, Mr. Chairman, it wasn't on official town letterhead, it didn't provide appeal rights. This was clearly just a review for Mr. Craven's benefit. Finally, the Narragansett zoning ordinance at section 23.3 provides that only a person who is an owner of a parcel of land or a person with a bona fide legal or equitable interest in a parcel of land has the right to request a zoning determination from the zoning official. The zoning board has no authority to determine whether a zoning ordinance provision is valid, and that's Slauson versus Zoning Board of Barrington. The board's duty is to assume the validity of the zoning provision controlling its decision. So pursuant to section 23.3, only a property owner, a lessee, someone, probably a prospective buyer under purchase and sale agreement, can ask for such a determination. Unless you have any questions for me, that's about it. We ask that you heard from Mr. Pimentel, it's clearly not a decision. This is just an effort to keep us in court, keep us before the boards, and just harass my client. Thank you.
Thank you. Excuse me. Thank you, Mr. Chairman. So I just want to put a little bit of context to this. There is a Superior Court action that's pending. And what did the Teveros and Glantz filed? They filed what's called the declaratory judgment. And declaratory judgment is simply a request of the court to discern particular rights relative to a legal document or a dispute. The Teveros and the Glantzes have this 2004 zoning decision that they believe is an important document. And that document is important because it governs the rights relative to the DePreetz property as it concerns the implementation of a pool. In 2004, this zoning board decided to grant specific relief. It granted a special use permit and it granted dimensional variance. And as you know, you do it every month, time and time, again and again. And you balance the interest of the zoning ordinances with the application and the concerns that abutters have. In 2004, that's exactly what that zoning board did. It granted the special use permit, it granted the dimensional variance, and then it inserted conditions and restrictions and planning board staff recommendations. So the question before the court is, what do those restrictions, conditions, what do they mean in 2025, 20 some odd years after? And the vehicle to ascertain those rights is this declaratory judgment action. When we were in court, the DePreetz other counsel argued that the Teveros and the Glantzes have no right to be before the court. They should be in front of the zoning board. They need to exhaust their administrative remedies. They need to come to this body, to the zoning enforcement officer, to determine what they did, they being the zoning board, the town of Narragansett. You, judge, don't have the right to do that until the zoning board has acted. My argument then, as it is now, and it has not changed, is that the Rhode Island Supreme Court has allowed a vehicle by which parties, property owners can ask the court specifically the question of, What's this document mean? What are the rights of this document? Unfortunately, that's all you can get from a declaratory judgment action. And as the court identified, I can give you a declaration, but what does it mean? I can't enforce it, because my solicitor's right. The only people that can enforce it is the zoning enforcement officer, the town solicitor in certain instances, and you, the zoning board members. And so,
I don't want to interrupt you, but I do want to ask one question while you're on that point. So if the Superior Court in the DJ action concludes that the document means X, and that X is non-compliance with the 2004 decision, wouldn't then Mr. Pimentel have to issue a notice of violation?
if the order, well, yes and no. So, and that's a very good question, because initially, we did not include the town as a party. My client didn't want to sue the town of Narragansett. They weren't a party to this, so it was simply the two property owners. But under a DJ action, the court, citing particular case law, noted that you need all necessary and indispensable parties. And obviously, the most necessary party for enforcement would be the town of Narragansett. But unless the judge makes a particular order that says, you have to do this, and in a DJ action, he may not. So to answer your question, yeah, I can get a letter or an opinion from the judge that says there are non-violations. I then can give that to Mr. Pimentel, and as you know, I can write letters, and I'll probably write a letter every other day saying, hey, you gotta do this, you gotta do that. But at the end of the day, it's his interpretation of that zoning board decision, and it's his determination as to whether he will or will not enforce it. If he doesn't enforce it, that becomes a question, do I go to court or do I come here? Where do I appeal it? And now we play a game of, is non-enforcement, is that not a decision or not a decision, or is it a decision? So there's two things in play here. One is the DJ action, which starts the ball rolling. So this isn't an attempt to delay anybody their property rights. This is an attempt to decide and determine what are the property rights. And my client is exhausting his remedies to determine how to get to adjudication. And this memo is part of that adjudication. So when they argue that this memo is not a decision, it's not intended to be a decision, well, Judge Gidney in the contemporary V. Murphy case made it very clear, you don't have to necessarily look at what the intent is. You have to look at what the impact is and where the document's coming from. I have a document that's been drafted by a public official who is the zoning enforcement officer for the town of Narragansett, who has made a review of certain documents, all public records, relative to 40 Newman Avenue and the abutters, who's made an interpretation regarding those documents, who has certain opinions regarding those documents. He's memorialized that in a writing. He electronically signs it. He puts his name on the bottom. The document doesn't say draft. It doesn't say working order. And then the document's appealed. No one says you cannot appeal it. And then at the 11th hour, 20 days prior to the hearing, there's an email that says, oh, I met with Mr. Dupree, and he's right, this is not an appealable document. Well, I think that's a bit too late, because not only has the horse left the barn, but the stable of everybody else has as well. And then there was a stipulation, there was a agreement among the parties, and when I say among the parties, between the attorneys, that, hey, I'm gonna appeal this document. So I wasn't acting under the nefarious dark cloud of trying to sneak an appeal in. I contacted the solicitor and said, hey, I'm going to appeal this document. It's not recorded. Are you going to record the document? Because the recording of the document's important to me, so I know the date by which I have to appeal it. And the email correctly responds, no, it's not recorded, but you received it on X date. We'll agree that December 8th is the operable date by which you should appeal it. I said, great, I'm going to send you a stipulation because this is very contested, so we want to document that. We filed our appeal on December 5th. We went through the process. The check got cashed. The abutters list went out. Notice to the abutters was given, and the matter was docketed. We were never told that it was not a decision. So our position is, in the first place, it is a decision. It has all of the markings of a decision. It comes from a public official. It has an impact, and it's going to be relied upon. Mr. Pimentel testified to the fact that it's going to be relied upon, and that When a public official makes that decision and it's relied upon, there are consequences from it, and and the parties who are aggrieved need to have an ability to be redressed, to review their rights versus that appeal. So that's our first argument. I think you can put that in the category of if it's a duck and it walks like a duck, you know the old adage, it's a duck. This is a duck. This is a duck. The second argument is, well, if it's not a decision, then no decision is a decision. Look, we've been requesting all the correspondence that we've submitted to the town. We've asked the town to do something. The town hasn't done anything. So what does a resident do when the town does nothing? Do they just go away? Is that the process? The process has been clear that any decision, which includes no decision, is appealable. And this is the body to which you appeal it. This is the body that's charged with this is the body who's given quasi-judicial authority to review ordinances pertaining to zoning, pertaining to official acts of zoning officials. And I said in my memo, Pimentel's the zoning guy. Well, you're the zoning board. You're the one that determines these issues. If we don't come here, there's nowhere else for us to go. So we think that this is a decision on its own face. We think it's a decision because if it's not, then it's appealable, and the board should review this. And finally, we think it's a decision based upon the fact that the actions manifest a decision. So Mr. Pimentel may not have thought that he was drafting something he may have thought he was drafting a working document. But that working document, once it was disseminated by the town solicitors to the public, and I'm a member of the public who's relying on this document, I have the ability to appeal it, and I should be given the right to appeal it, to decide what is the town's position and interpretation of the 2004 zoning decision. That, I think, is crucial. So there's essentially two questions for you to review. One is whether this is a decision, and then in that umbrella, whether or not, if it's not a decision, whether or not a non-decision should be appealable. And then secondly, the dissemination of the document. What happens there? Does the fact that it was mistakenly thrown out to the public now just get retrieved back? Is this one of those opportunities where you can unsend an email that you didn't want to send? I think that's long gone here. I think that the conduct that has arisen from that can be relied upon by Mr. Tevel and Mr. Glantz, who have been aggrieved by this. Look, in sum, at the end of the day, all we're looking to do is get a determination. Look, we've amplified this as loud as we possibly can. We're looking for determination as to what do those conditions in the 2004 decision mean, and are they applicable in 2025? And that's an important question that I think the town of Narragansett would want to know, especially zoning boards. And a zoning board like this that issues these types of decisions day in and day out. Do these decisions die with the property owner, or do they run with the land? My understanding of the law, and I've been wrong before, Supreme Court's told me many times, that these decisions run with the land. So if they run with the land, they have particular consequences to these property owners. These property owners being the Tebro, the Glances, and the Dupreets. And I think that has to be adjudicated, and this is the proper body for it, and this is the mechanism to do it. We have a decision now from a building official that has interpreted the actual document that's in dispute here.
Mr. Mancini, I just want to ask you one more question. With respect to the zoning status review, which is the way it's titled, do you agree that there is nothing in this document that says the Dupreets have to do something or refrain from doing something? Do you agree with that?
No, I don't, because the document, here's the issue with the document, and Mr. Pimentel testified to it. He says that the restriction of vegetation it's the last bullet point. The last bullet point is a particular interpretation, and the last bullet point is a particular interpretation, and it is the key interpretation to the 2004 decision, which is where is the vegetation to be located. And Pimentel makes a very clear decision. He says, my interpretation of this recommendation would be that the vegetation is limited to the westerly property line between the Tevro and the Dupree properties only, not the entire westerly side. That runs counter to the decision itself and to the party's understanding of that decision. That has a major impact. That is what's being appealed. That's not a personal opinion. That's not a status. That's not telling me what the zoning is in 2025 relative to 2004. That tells me that that the zoning/building official for the town of Narragansett has interpreted the restriction in the 2004 decision to mean that westerly side is just the boundary line. That means that you can have vegetation on the boundary line no more than 6 feet. But if you're 10 feet off the boundary line, then you can have vegetation 30, 40 feet. And that would be illogical and not sensible to what was being discussed and what was being approved in 2004. What was being approved in 2004 was a reduction in the rear yard setback and location of the pool closer to the side setback, which is Mr. Tevero's property line. The rear yard setback was Mr. Glance's property line. So that pool, the location of that pool, the shed, which was to hold the accessory equipment, the pool equipment, was all being shifted and moved towards two property owners, 404 and 38 Newton Avenue. And it was being done, it could only be done if the variance was granted, and it was granted subject to the conditions. The concerns of the abutters was the view corridor. So if the view corridor was limited to the boundary line between Tevero and the Glance, and you could only have vegetation at a certain height.
Mr. Chairman, this is all the substance.
This is the substantive.
Yeah, but I'm answering your question.
I know.
Right? And the interpretation of your question, and they're breathing down my neck. So if you don't want to hear me, just say you don't want to hear me. That's fine. There's other avenues. I get it.
I just want to respond to a couple of the statements that Mr. Mancini made. You know, it's funny how he says that they were not working under the cover of darkness. They filed this appeal on December 5th. Didn't give it to the Dupreets. The owner of the property didn't provide a copy of the purported appeal to the Dupreets. We found out about it. One of these attorneys that's working for the town sent it to us on December 23rd. That's when we found out about it. If I had received it on December 5th, we would have been involved much earlier. So when we look at this zoning status review, and it's clearly meant for Mr. Craven's review, and it's clearly, meant for some kind of a court thing, what about this January 2nd email to Mr. Mancini from Mr. Pimentel, where Mr. Pimentel says, this decision is not appealable? Is that now a decision that's appealable? Like, take that road, right, about every single statement that Mr. Pimentel makes is now a decision that's subject to an appeal? That doesn't make any sense. It's ludicrous. They haven't asked for anything. In my notes here, I literally screenshotted every letter. I don't want to put you through it, but if you want to look through it, the December 12th letter, he notifies them about a court case. In the January 22nd letter to attorneys, he notifies them of the litigation and demands issuances of violations. It's all of that. I summarized it for you in my argument, but they didn't ask for anything. They never asked for a legal determination. And then in his papers and just now, Mr. Mancini said that the town solicitor disseminated that zoning status report. It was not the town solicitor. It was an attorney named Mark Hickey who was working for the town on an insurance matter. We don't know how he got it. I don't think anybody here knows how he got it. It was disseminated. It was mistakenly disseminated, and that's why we're here. But this was not a decision. You have testimony to that effect. Thank you. Yes, I'm sorry.
In the context of the Superior Court case, did counsel for the Dupreets state to the court on the record that Glance and the other gentlemen have to exhaust their administrative remedies with the town before they proceeded with the Superior Court action?
I have not seen any of that in the record. I have not participated in the litigation. I just entered my appearance last week. but I have not participated in any of those discussions. If you look at the
Well,
transcript.
it's not a discussion. I'm asking whether that was stated to the Superior Court judge. Do you know either way?
I don't know either way.
Well, let me ask you this. Well,
Yeah.
hypothetically, if Mr. Mancini can establish that that was said on the record, my question to you would be, what is the remedy if you're saying in Superior Court you have to go through your administrative
Right.
remedies, and if you're saying here
Yep.
there's nothing to appeal? What's the remedy for the
So-
people that are complaining?
So only the zoning official can enforce the zoning ordinance. That has not happened. If the zoning official were to decide that my client is in violation of the ordinance or this 2004 decision, he would issue a notice of violation.
All right, so
That would be appealed to this court, to this board, and then your decision could be appealed to Superior Court. That is the exhaustion of administrative remedies.
And I understand. So what you're saying is, we need the zoning official to issue a decision, either affirmatively or negatively, on the complaint, make his decision.
No, nobody's asked him to.
All right, I'm relatively new to the
Yeah.
zoning board, but what I have seen happen is people make complaints. We had them last week on Gibson. People make complaints. The zoning officer conducts an investigation, and then he issues a determination with thumbs ups or thumbs down. And the person that's aggrieved by that comes before us, and then we have a hearing. I'm not saying that that's happened
Mm-hmm. It
here.
hasn't.
Nothing has happened.
Right.
So are you saying that if he were to issue a determination, thumbs up or thumbs down, it could then come in front of us?
Not if nobody requests it. Nobody has requested anything.
You're saying there was no complaint by these two gentlemen?
These two gentlemen are, Mr. Dupree is sitting here.
Oh, I'm sorry, I've got the wrong parties. I apologize.
There have been complaints, but complaints get filed with the building official, zoning official, all the time, daily basis. The zoning official or building official goes out to the property, decides if they see a violation, and if they don't issue a violation notice.
Well, what do they issue then?
Excuse me?
Do they issue anything?
No,
They say not
no.
sustained?
Why would they? You'd have 20 appeals every night. that
You're
here.
talking about floodgates as the argument for not getting the decision. I'm saying, should there be one?
No, absolutely not. Absolutely not. That's not the process. The process is, and the authority under the building official and zoning official, is that they enforce the zoning ordinance. They're the ones that enforce it. People can make complaints to bring things to their attention, and then they go out and investigate, and oftentimes they issue a notice of violation. Oftentimes, they do not, because there's no violation. There is no violation here. I mean, I shouldn't say that. We are aware that we have to do one thing on that property that we intend to do. We have not been issued a violation on that. Other than that, our position is there are no violations on that
I
property.
agree with you that you haven't been issued a violation. I'm just probing the question of whether there's been two arguments, one saying you've got to come back before the zoning board before you go to Superior Court, and coming before the zoning board saying you don't have any authority to hear this.
But procedurally, there's nothing that gets us to the zoning board other than what we've discussed tonight, such as a notice of violation.
Fair enough, thank you.
Thank you. Anything else?
I apologize, I just want to correct the record. So the first response is with regards to notice. When the appeal is filed, as the board's aware, I don't have to give notice to all of the abutters that the appeal's been filed. Once I file the appeal, I get the radius map, the abutters list, and I mail notice. That's what we did. So I didn't have to pick up the phone, I didn't have to send a text or an email to everybody in the world to let them know that I filed an appeal on December 5th, 2025. There's nothing nefarious about filing an appeal of a decision that I believe is a decision. And then you hear, and you've heard multiple, that these neighbors have not asked for there to be any action. Well, the first letter we submitted on December 12th, 2024, in the second page, the last paragraph says, "Please allow this correspondence to serve as notice to the town of the plaintiff's complaint filed in Superior Court a copy of which is attached here, including all exhibits. Additionally, please consider this correspondence as a formal request to the town to issue notice of violations for all of the violations mentioned herein in our complaint. I said that on December 12, 2024. Look, English is not my first language, but that's pretty clear to me that I've asked for a violation. I've asked for a review back in December of 2024. No investigation, to our knowledge, was undertaken until we received the memo and dated October 28, 2025. And now they say that this memo somehow shouldn't have fallen into our hands because it was given to us by Mark Hickey, who is an attorney for the insurance company on behalf of the town. Well, Mr. Hickey represents the town. He's your lawyer in this case, in the Superior Court. He's there on behalf of the interlocal trust. That means something. That means a lot. And when I get a document from a lawyer who's in the case, and I rely on that document, if I can't rely on what a lawyer says to me, emails me, or tells me, then the system is going to fall apart. It's a bad argument, and it's just not right. Finally, the question, and Ms. Salvador doesn't know, she hasn't been to the hearings, but it was said to the court by Mr. Stone, who's counsel, and I've got the transcript, I've attached it to our papers. Judge McBurney made a very clear inquiry, which was, hey, why is this here? What are you doing here? You know, do I have jurisdiction to hear this? My argument to him is you do have jurisdiction to hear this under a specific case, which was the Johnson and Wales case, City of Providence, Johnson and Wales, that says the Supreme Court carved out the ability to be there on a DJ action. They argued that we didn't have standing to be there and that we needed to be here. My argument to that was there's no mechanism to be here. I can't get before this board until somebody makes a decision. Then I come here. You know, when you look at your forms, there is no form that says cross this, there's no form that says check this box to appear before the zoning board for a violation or non-violation. It has to come through the building official. So what did we do? We filed the complaint in Superior Court in December of 2024. We give the town notice of the complaint. Here's the complaint. We tell the town what our violations and what our concerns are, and we ask you to issue a notice of violation. You've done nothing since December of 2024. We now, because there's no decision, we can come to you and say, there's no decision. Is someone going to do something? Now we do have a document which purports to be a decision by all terms of reality and by the pure definition of the dictionary, which is a determination and a finding, and we've appealed that. And we think that we're entitled to a hearing on that document and on the 2004 decision. So with that, I was going to call you Your Honor. I don't know if that's a promotion or...
That there was no decision.
I'm sorry?
Isn't your argument that there was no decision tantamount to you asking us, who I don't think we have any jurisdiction to, basically, it's like a mandamus petition.
No.
You're asking us to
It's an alternative pleading. So if you decide that the building official made no decision, so if the October 28, 2025 memo is not a decision, it's not appealable, it means nothing, it's a working document that essentially cannot be relied upon, has no impact, does not contain any official determination or finding or interpretation of the building official, then that means that the complaints that have been filed repeatedly since December of 2024 remain unanswered. So that is not a decision. So I'm entitled to appeal a non-decision of the building official, which basically says, hey, this is what we gave the building official. He hasn't decided it. Should he decide it? Should he make a decision? You have that authority to do that.
So you think we have the authority to compel Wayne Pimentel to make a decision?
No, you don't have the authority
Or
to compel.
to conduct an investigation? I don't think we have that authority.
You have the authority to interpret your decisions. And the request in the documents and in the information provided is for you to determine what are the conditions that the zoning board implied. You know, the other way is we could file a motion to modify the conditions in 2004. You get a lot of those, right? The zoning board issues a decision, there's conditions, there's restrictions. Sometimes they can't be complied with. There's a request to modify or change the restrictions. Well, here, the question is, do these restrictions apply? A, what are the restrictions? And what were they in 2004? And do they apply in 2025 or 2026 now?
Does anyone else have any questions?
I have a question. Mr. Mancini was, he stated something about the owners, the neighbors complained. No decision was made by the building official. There was no notice of violation, no nothing. But he said that they have a right to appeal that no decision. Is that correct? I mean, I'm trying to, that I don't know.
John, did you mention a site for that? That's,
Yeah, so I'm citing the Gateway case. And in the Gateway case, there was a request for a zoning certificate. It was never issued. So they appealed it to the zoning board, say, there's no decision here. Ultimately, once it got appealed and got to the zoning board, the building official made a decision.
I think that may be the distinguishing factor where there ultimately was a decision. Because if you get to a non-decision is a decision, there are so many factors that would arise. How much time has to pass? What are the facts that have to come up? That would be such a fact-determinative determination ultimately by a court. And that's why that's why I asked if there was a site, because it's not a case I'm familiar with. So that would have been news to me.
And he's also referring to a totally different statute than what he's relying on. So there's another statute that says if you request a determination or a zoning certificate and there's no response, you can appeal that. There's probably a time period. The last time, and by the way, he wasn't asking for information. A zoning certificate or determination is a request for information, okay? It's not a demand to issue violations. And in that case only, if the zoning official doesn't respond, that non-decision can be appealed to you. But not a demand to issue violations. That's different. It's just not a thing.
I have a question, and I'd like to ask Nick the question. Nick, do you want to, could you weigh in on what council just talked about? Because that was going to be my question to you.
Right, I'm inclined to agree. I think it's, and I was just speaking with Ryan a minute ago, where that particular statute has a time element to it, and actually just changed recently in state law where it was 10 days where a zoning certificate has to be issued, or it was 15, now it's 10, or vice versa. 20, thank you. Where specifically from the General Assembly to your ordinances, if no action is taken, then you can appeal that. I think that's not what we have here.
Because this would be a violation.
It would be different. It'd be an NOV, yes.
And with the decision that was made back in 2004, that the zoning board, they made a decision. If someone's not complying with what was laid out in the decision, who's the governing body? Is it the zoning official that would go and make the decision of whether they're in compliance or not? And then a violation would be issued or not?
That's where it usually begins. It usually originates with a complaint from generally an abutter or somebody who identifies an issue. Wayne gets these tenfold every day.
So if Wayne doesn't find that there's a violation, then they could bring it to court, right? It doesn't leapfrog to us.
To get to you by statute and codified in our ordinances, you need a decision from Wayne. Wayne's decisions are appealable to the administrative officer, the building official, zoning official. Their decisions are appealable to this board, and in those circumstances, you stand in his or her shoes to decide whether or not a violation exists.
Could I just follow up on that? And and the only decisions for something like that we have seen that we know of are things that have been called notices of violations. Those are the decisions that we've seen when there's been a complaint,
That's
an
generally what you-
investigation, and
That's
then a
generally what
notice
you
of
see, and
violation.
we've seen a number over recent months. I think we see maybe 2 or 3
Yeah.
every agenda recently.
Our role would only be to either affirm or reverse.
Right.
Wayne, that's it.
Now, from this memo alone, this is more on the substance. I mean, there's things that the Dupreets have agreed to remedy, so maybe, I mean, that must have been through some sort of negotiations, right? But a notice of violation of those have not been issued. Is that right?
Notice of violation has not been issued, I'm
Okay,
sure.
okay.
I beat you to the mic.
I mean, there are a couple of things that seem, this is more on the substance, and I know we're not here tonight on that, but there are a couple things that that the Dupreets have agreed to remedy from that
Yeah,
2004 decision.
Maybe so, and
Okay.
you alluded to it. I
Okay.
wouldn't address that tonight. What's before you tonight,
Right,
what we continued this
And
matter to
that's what I-
specifically is the pending
Right.
motion.
Okay.
Yeah, go ahead, David.
There's been no violation issued by the building official.
Correct.
Therefore, I don't believe this board has any right to make a determination. If there's no appeal, it would be coming from the Dupreets if there was an appeal, asking us to make a determination to deny it or affirm it. If there's no appeal, I don't understand, we can't make a determination. There's nothing to determine.
Well, that goes to the ultimate question tonight. So there was an appeal. I think the question is, should there have been an appeal, or legally, is what is before you a proper appeal? Meaning, was a decision appealed? So that is the question the board has to decide. Is this what is before you, this few-page document, a decision?
Yeah.
If it is, the appeal may be proper and it can proceed. If it is not a decision, then this board is without jurisdiction to proceed, and you may grant the motion to dismiss.
I have a question now. So if this is a decision, if this is to be considered a decision, this zoning status review by Wayne Pimentel, wouldn't it have to say what they're violating?
I think Attorney Mancini would say that any formal decision, any formal position taken by Wayne is appealable. And he would argue, and I don't want to put words in your
Okay.
mouth, John, that a determination by a building official in turn aggrieves his client, which makes it a decision, which puts it in your hands.
Okay.
So does this document have the force that aggrieves his client may be a different way of looking at the same question I just put before you a minute ago.
Thank you.
So I have one more question, and I think I'm looking at it more from a due process point of view as opposed to, who said what and where the cases are superior here. You have a complaint that's made, and no action is taken on it. Are we supposed to, how do we handle non-action by the zoning official? Is that, I know there's no violation that issued, but we also don't know if he's found it to be in conformance because we don't have anything in our hands. From a due process point of view, for the person who complained, how are we supposed to handle that?
And great question. Mr. Mancini alluded to it tonight, where, I'll start with this. I think there's a fair amount of discretion that our law gives our administrative officers, similar to policing, where a police officer may make a discretionary determination. Okay, I'm not going to issue a ticket on these facts. That is the position we put our administrative officer in. The argument that a non-decision can be appealed, I'm not sure has been litigated. The Gateway case with Mr. Mancini's rendition of it, I think is factually different. So it may be a novel question that I'm sure will be dealt with in a different forum.
All right, so you're saying we may have an issue of first impression. I'm going to go to your example, though. If a police officer doesn't exercise his or her discretion to issue a complaint, the remedy there is you go to the magistrate and you ask that a complaint issues, or you have some other process. What I seem to be hearing here is because no action was taken, well, we don't get to do anything either way. Or we just don't know because it's an issue of first impression.
Or maybe there will be an action taken, it just hasn't been taken yet. And I would suggest often when a lawsuit is filed, and the lawsuit was filed some time ago, but the town was brought in thereafter, that often has a chilling effect on staff taking actions on the property. So that's a more practical answer to your question, that, oh, the town got sued, let's see what's going on in court. And there may have only been one conference with the court in this case. There was actually supposed to be one this past Monday to get some direction, but it got snowed out. So we hear December 2024, oh wow, that was a long time ago. Not when it comes to litigation.
Well, I guess the determination we need to make, which is whether to grant or deny this motion to dismiss, my view, and I'm troubled by. Sure.
Follow up from my sister's point here. So the idea of no violation, the decision, the zoning status review by Mr. Pimentel finds violations. They just weren't cited, and then they say they're corrected. So how do we ignore that, where it says unpermitted pool filter enclosure measuring 4 feet 9 inches by 13 feet was constructed by previous owner. And it says pool filter enclosure will be removed by Dr. Dupree, and the pool equipment will be protected with a fence enclosure. And then he finds another violation. It says the current height, Dr. Dupree agrees to reduce the size to 1014 to comply with the original decision. The original decision is the 2004 decision. So these are violations. They haven't been formally violated, and the question is why? Why is there no formal violation? If this isn't a decision, if this isn't a determination of compliance and non-compliance, then why hasn't no notice of violation been issued? And then the other troubling issue is, on January 2nd, 2026, we get an email from Mr. Pimentel that says, Nick, I met with Dr. Dupree on Wednesday regarding the fence permit, and we discussed this issue, and it is our understanding that Bob was going to write a legal response to my findings that would be submitted to the judge for final determination on the previous zoning issues. We both felt this was not something that could be appealed to the zoning board. So your building official and Mr. Dupree both feel that this is not an appealable document. That doesn't comport with due process in my read of the law. And in my read of this zoning status report, it's not a status, it's a finding of violation. And then there's obviously discussion had between Mr. Dupree and Mr. Pimentel about how to correct those violations. And the abutters who've been complaining, who've not demanded violations, they've requested for review and violations, have been shut out of this process. And now again, they're shut out because they can't appeal this because someone decided this is not an appealable document. It's a working document. It's not something you can appeal. You can't even look at it. Apparently, we shouldn't even been reviewing it. Mark Hickey made a big mistake. You guys should talk to your lawyer about it.
I have a motion to close the hearing.
So moved.
Second. Anyone second? Second. All in favor?
Aye.
So, Nick, I'm not exactly quite sure how to proceed here. We've had, obviously, many appeals before us, but, I mean, I'll just make my comments, and other people can weigh in too, but what I'm troubled by most is that I think it's beyond dispute that this document was specifically prepared by Wayne, intended to go to the town solicitor for whatever purpose he requested it, and that would mean to me that there was no intent to issue a notice of violation of anything. And the fact of the matter is, at least in my view, that this zoning status review is a document that was provided by council for whatever reason, and I don't think it matters in this context. It was distributed to another council, who then distributed to Mr. Mancini. Obviously, if it was an attorney-client privilege document, that privilege was probably broken, but I don't think it matters with respect to what we have before us. I just don't see that there was a notice of violation that was issued to the Duprees, which would allow them to appeal, not the neighbors. If there was issued to the Dupreets, they would be the ones here appealing the finding if they thought it was wrong. It wouldn't be a neighbor appealing that. So, I mean, my view is that we should grant the motion to dismiss, because I don't think we have jurisdiction to rule on something. Well, there's nothing for us to rule on. There's no notice of violation for us to rule on. That's my view.
I agree that the evidence is, it seems pretty compelling that this document was not a decision and intended to be a decision. Again, I do see that, there are potential violations here, but we also don't want to curb the ability of the town to, allow the violations to be corrected before issuing a notice of violation. I mean, you said, they haven't issued a notice of violation. I think the word needs to follow that is yet. They may have at one point if these things weren't corrected. So, but I do agree that this document is not a decision that we are able to act on for the appeal. So I think think that the motion to dismiss should be granted.
Are there any other comments, board comments?
I would agree to what you both said. It's unfortunate for neighbors to have to go through this, and just hope that they could reach over the table and try and figure things out, but I don't believe that this is something for us here tonight.
Someone make a motion to grant the motion to dismiss?
I make a motion to grant the motion to dismiss.
Second.
Just for the motion, I would just put your factual findings on the record supporting your conclusion that the motion should be granted and that this is not a decision. So maybe you might say, I don't want to make the motion anymore. But whoever makes the motion, I want all of your findings as to what you found based on the testimony and argument this evening that supports your decision.
So I made the motion to grant the motion to dismiss based on the evidence presented here that this document, and I think this is the only factual issue, this document is not a decision that can be appealed. We heard testimony from Wayne, from Mr. Pimentel, saying that he was requested to prepare this document by the solicitor, the assistant solicitor, in anticipation of litigation and in anticipation of court proceedings. That Wayne does not believe that this is a decision at all, that it's just prepared at the request of one of the town's attorneys, that it was never intended for it to be published publicly. It happened to be sent from an attorney who represents the interlocal trust, which is the town's insurer. That attorney may or may not be considered to represent the town in that case as the interlocal trust attorney, but it was not disseminated by any town employee. Anybody else have any facts that they want to put there? But I do believe that the evidence presented tonight pointed to the fact that this is not a decision, was not intended to be a decision.
Keith, were there any facts you wanted to add to the motion?
I think we just incorporate by reference the arguments made by counsel, the testimony of Wayne, and the comments that you made with respect to this. So is there a second?
Yes.
Oh, David, you made, I'm sorry. All in favor of granting the motion to dismiss?
Aye.
That's it? Motion to adjourn?
So moved. Second.
All in favor?
Aye.
Aye.